Be ready. Start. A narration of the charges and the reasons of the inquiring authority for accepting the charges as seen from the records shows that the inquiring authority has based its conclusions on materials available on record after considering the defense put forth by the appellant, and these decisions, in our opinion, have been taken in a reasonable manner and objectively stop. The conclusion arrived at by the inquiring authority cannot be termed as either being perverse or not based on any material, nor is it a case where there has been any known application of mind on the part of the inquiring authority. Stop. Likewise, the High Court has looked into the material based on which the inquiry officer has come, R.S. Saini versus State of Punjab and others, on 9 September 1999 Indian Qanun, to the conclusion within the limited scope available to it under Article 226 of the Constitution, and we do not find any fault with the findings of the High Court in this regard. Stop. The other two complaints made before us, that there has been flagrant violation of principles of natural justice, and the impugned order in question was the end product of malice entertained by respondent number 4 against the appellant, were also, in our opinion, rightly rejected by the High Court. Stop. It is found from record that the two detailed show cause notices enumerating the various charges giving necessary particulars were issued to the appellant, and the appellant had filed a detailed written reply with reference to each one of the charges. Stop. The record also bears out that the appellant has been heard through his counsel, and the complaint made that he was not given sufficient adjournments for further hearing. Stop. In our opinion, would not constitute a breach of the principles of natural justice. Stop. As has been noticed by the High Court, the allegation of malafides having been answered by respondent number 4 by way of an affidavit denying the same, and the High Court having chosen to accept the affidavit of respondent number 4, and rightly so, in our opinion, we do not find any material to differ from the said finding. Stop. We have noted earlier that the scope of judicial review in matters of this nature being restricted, the High Court had to consider the challenge to the impugned order with a limited degree of scrutiny that was called for. Stop. We too have considered the complaint within that limited scope in order to find out the correctness of the allegation that the impugned order of the disciplinary authority suffered from the vice of perversity, non application of mind, and tainted by malice, and having come to the conclusion that the report of the inquiring authority cannot be faulted with on any of the grounds stated above, we are unable to agree with the appellant. Stop. For the reasons stated above, this appeal fails and is hereby dismissed. Stop. No costs. Stop.